Hmm. And welcome to this video where we will be discussing about the loss aspect of CISSP, especially in terms of security and risk management. It is discussed in conjunction with the legal and the regulation aspect of the loss, which is very important for a CISSP professional to understand and to be able to differentiate between the different kinds of it. So, for example, criminal law is something which is adhered to making sure that any victimization of the society shall not take place and that the victimization concepts are proven beyond the reasonable doubt. So, it is done and it is exercised in terms of death penalties, financial fine, where the main aim is to punish and deter the perpetrators who, in one form or the other, victimizing the society. For example, violence, murder, theft, etc. Civil law, which is also called tort law in UK terms, for individuals and group of organization where the victimization needs to be proved based on majority. So the main purpose of civil law and tort law is to extend financial fines in order to compensate the victims. For example, violation of the civil liberties. Administrative law, which is also called regulatory law, is enacted by government in terms of maintaining the law of the land. For example, health data protection, exchange of foreign currencies, etc., are some of the examples which are covered under administrative or regulatory laws. Custom laws or customary laws are based on the personal conduct and patterns of a particular region or society or the section where it has been followed. For example, the way people follow certain patterns in Middle Eastern countries is very different from European countries, is very different from US and other Asian countries. Extending to that is the religious law, which has its root in the religious beliefs of the particular country, and it is included in the code of ethics and moralities, which needs it to be required and upheld. Private regulations are dominantly not laws, but they are good practices to be followed in order to conduct a business in certain set of industry, like we will see in a couple of slides later about PCI DSS, which is a standard formulated by payment card industry. Now it is important to understand that compliancy to this law is in terms of adhering to the mandate of the regulations, standard processes and procedures. However, please keep a great distinction that being compliant doesn't make you secure. Also, it is important to understand for CISSP professional that the jurisdiction of a particular law plays a very important role. So, for example, if a crime or victimization has happened in a Middle Eastern country, the law of Middle Eastern country will be applicable even if the victims are not from the Middle Eastern countries. In terms of standing the law and making a fine distinction between that, for example, in US, Misdemeanor and felony both are considered as criminal act, but with varying degree of punishment. Misdemeanor is something which may entail you financial fines and no jail time. However, felony can get you a jail time minimum of 12 months and financial fines. One of the two major continents that has been now covered under CISSP, though it is agnostic to any industry, rules and regulation of US centered is something quite prevalent. For example, HIPAA for the health insurance portability and accountability, adhering to protection of patients' individual private data. Also related to electronic communication privacy in terms of exchanging information, and the Patriot Acts, where appropriate tools can be used to intercept and obstruct terrorism. Also, Computer Fraud and Abuse Act is one of the most commonly known acts there. And similar to this, in other countries, like in Australia, there is Cybercrime Act 2001, which follows very similarly to the Computer and Fraud Abuse Act from US. For the exam, it is important to know some of these, but you do not have to memorize all of them. In terms of regulation, as far as European Union is concerned, it is majorly driven based on the data privacy. That's why the data exchange between EU, US, and other countries was initially held liable to the law of EU-US Safe Harbor Act, where it was considered that the data which is secured in EU may have the same protection level in US. It was further extended by Privacy Shield, where it was incorporated in the corporations operating out of US and processing EU processing data from the people of EU. However, this has been marked as non-compliant in 2020, and this is called the SCUM-2 decision, which you can read more about this in the slide. Both the EU-US Safe Harbor and the Privacy Shield were precursor to GDPR, the Global Data Protection Regulation from European Union. And in terms of GDPR, it is very important to understand the difference between what a directive is and what is a regulation. GDPR is a regulation, but precursor to this, there was also a data protection directive. And the difference is that the directive can have a local interpretation. So among the various members of EU, they can all have their local interpretation. Regulation, on the other hand, needs to be applied as is the way it is written, and no local interpretation is allowed. As said before, in terms of the industry standard and compliance requirement, this is not majorly a law, but this is good to be part of in order to conduct business in that particular part of industry. Payments and payment card processing is one of the most important in that criteria, where PCI DSS, as it is called, is useful for the member participant to adhere to certain requirement in order to process the individual or bulk payment. There are more, for example, Graham-Leach-Bailey Act, which is driven by the federal financial institution and applicable to them, and also Sarbanes-Oxley Act, SOX as we call it, which is to make sure that the accounting scandals and whatnot is not propagated deeply into the system. So with that, I'll stop here. Thank you very much for listening, and keep learning.